And before I hand over the chair, or give the chair, so to say, to Professor Cesar Landa, I want to say something for first. After this session, we will have lunch in a beautiful restaurant nearby. They will take us, I think at 2 o'clock we come there. And then in the afternoon we come back because we have lunch from 2 p.m. to 3:30 p.m., 1.5 hours. This is necessary, I think. Then the next session, the last one, fourth session, will be start 3:45. However, I must say that, well, as it was announced yesterday, there is a how to say, a service for Catholic Protestants, for Jewish, for Muslim faith in the cathedral, but they have to leave at 5 o'clock, so they must leave here. If we must stop anyway at 6, because then they close. But I want to say that, where is Tony? The bus will take, who wants to go? Well, our dinner will be again as yesterday evening in the Consejo General del Notariado. It's not the same, as they told me, the same meal. It is differentiated, yes. So, but it will be only, as it is very early for Spanish people, at 9. Even it's very early, but at 9 o'clock. This means that the bus comes. If you want to go with the bus to the hotel, the bus will come at, I think, 7:30. But I must ask Tony. I forgot now which time. And it's not as in the program as it was foreseen before. Not at 8 in the evening. The dinner, it's at 9. And you know where this is. It's quite near the hotel. It's possible to go to walk there. Yes. And yeah, this is for today. I will inform you, yes, then about the bus when and we're leaving from here, from the in front, or from the Real Theatre, Teatro Real. 7:30. Yes, this is what I have in mind. Okay, so Alexander, there's 7:30 p.m. Yes. Yeah. So the guide is always right. Then we have to be there down at 7:30. Okay. Yes. Then. But I should, yeah. But you decide whether to go to the cathedral or stay here. But we give you the opportunity, and of course, it is a important opportunity. And so, but you decide by yourself. This is clear, as we always respect the plurality of religion and the yes. So then for tomorrow, you know that we have to leave at 8:15. Let's be 8. The breakfast will be in a hotel from 7 on also. And tomorrow there will be important to have the passport with you, or your identity card. No? And you have also now this yellow ribbon, ribbon, then you will come be let in. Okay, I hope so, yes. Tomorrow there are two parts. One part is, but tomorrow is everything is World Law Congress. Yes, the first is some introductions I want to say to the we changed the program. What we will not do tomorrow, or they will not do tomorrow, upon my request, is also that the presidents of the constitutional courts have to go to the stage. No, we canceled this for, I think, several reasons, good reasons, and it's fine, so you can listen in tranquility to what goes on. And yes, and the second part is then with the king. And it's a third part. I think this is not in the program, and this must be confirmed. As Javier yesterday said, there is a meeting, a reception, or a cocktail with the king, but so I'm not the inviter, and so they must specify this. But okay, but then I think at about 2 o'clock or after 2 there will be the congresses finished, and then some people go, also me, to Malaga, but others stay here for going back on Thursday. We would like to organize for those who stay here a visit to the Prado, and maybe also a visit to the town. I will see. Thanks to our spontaneous collaborators, Professor Maria Ugena de Rey Juan Carlos y Dr. Santana Herrera, and maybe Christina will also come tomorrow, that we will give around a list. Please sign or tell us who wants to go to the Prado or to, I must say that I would suggest to have a bus, what is called hop on, hop off. You know this. And there is also coming to the Prado. Then you hop off, maybe there or before. Prado, from 6 p.m. on, it is gratis. It is the same. It's, of course, you can. I would suggest this one. The other one, well, I must say that if you would like to have this hop on, hop off bus to the monuments, and so this is about 20 euros per person. I think you know that. And Prado would be gratis from 6 on. Yes, but this we want to offer, and we should know, of course, when and where to meet. The best is to meet also in the Royal Theatre. No, when will we? 5, for example. Yes, but yeah, at 5. At 5 o'clock, because you need maybe some leisure time for your own, I don't know, but so we thought that if it ends at 2:30, then it's good to have 2 hours or 1.5 hours, and at 5. If somebody wants before, then we can also arrange, but only one group is possible. But maybe at 5 at the entrance of the Teatro Real. And Maria then will guide you, lead you to the bus station where this bus comes. Yes, so if you want to otherwise, it's of course your own decision. This is clear. But this maybe would be interesting. And in the evening, for those who remain here, in the evening, the hotel, the dinner is foreseen. It's for you. It's covered. Yes, you need not pay. I don't know how many beers are included, but you will see. You will see. Okay. Do you have a question to these pragmatical points? No. No, yeah. The people, the Malaga people, so to say. Now we have the tickets for the rapid train. Tony has them. They will distribute them, but please be sure that you will go there. If somebody does not want, this could be, then tell us very soon, but we have the tickets already. And they will hand it out to you, and we speak about that. Because I think there's, I don't know exactly if the trains are the same at the same time or is different, so I do not want to say too much about this. Okay? Yes, good. Then now I give the microphone or the chair. I ask for the chair by Professor Cesar Landa from Lima. Professor Cesar Landa, well known, of course. He was president of the Peruvian Constitutional Court and is very linked with German culture because he was a Humboldt scholar here for 2 years, I think, so, yes, and so, but he will speak in English, not in German. Then.
Okay.
Or in Spanish, please.
Thank you, Professor. Ladies and gentlemen, it's a pleasure to share this third session of our International Congress of European and Comparative Constitutional Law. And now we had to follow with the third session to finish with the development in Europe with the presentation of Daniele Ingrida. He is a professor in constitutional law in Vilnius University and also Secretary General of the Constitutional Court of Lithuania. He will speak us about the human rights and other jurisprudential constitution. You have the floor.
Good afternoon. Dear honorable colleagues, my intervention today focuses on two concepts of equally fundamental nature: human rights and the jurisprudential constitution. The development of constitutional review in Lithuania is inseparable from the concept of the jurisprudential constitution. The latter concept has never been identified by the Constitutional Court, which relies on the concept of the official constitutional doctrine instead. However, it is quite widely used by the legal scholars as meaning the official interpretation of the text of the Constitution and its meanings in the jurisprudence of the Constitutional Court. According to some scholars, it is indeed the specified or even the genuine Constitution. The Constitution perceived as the jurisprudential Constitution is vital for three purposes. First, only this concept can ensure the real supremacy of the Constitution, which implies the uniform and binding understanding and implementation of the constitutional provisions. Secondly, it ensures the stability of the constitutional order. Thirdly, it ensures the progressive development of the state and society. However, the jurisprudential constitution or the official constitutional doctrine may serve these purposes only when it meets the following main principles. First, the principle of gradual development, the principle of consistency, the harmonization with international and European Union law, and the inadmissibility of the interpretation of the Constitution based on lower-ranking legal acts. Instead, the Constitution may only be interpreted based on the constitutional provisions itself and on the existent official constitutional doctrine. Consequently, the very link between the concepts of the jurisprudential constitution and the rule of law has been expressly disclosed by the Lithuanian Constitutional Court already in 2006. The court stressed that the principle of the rule of law specifically implies the continuity of the constitutional jurisprudence. Here, I would like to come to the second concept of my topic by distinguishing just two of the chosen aspects of the provisions of the modern Lithuanian jurisprudential constitution which regard the foundations for the constitutional protection of human rights. The first of these aspects is the recognition and indisputability of the inherent nature of human rights, and the second aspect is the concept of the Constitution as an anti-majoritarian act. Firstly, the cornerstone of the constitutional doctrine, and thus the jurisprudential constitution on human rights, is the recognition of the inherent nature of human rights. The Constitutional Court has established that natural human rights constitute the minimum, the starting point from which all other rights are developed and supplemented. And thus, comprehensive protection of human rights and freedoms is impossible without recognizing the inherent nature thereof. Meaning that an individual is granted with certain rights and freedoms which are inherent and inalienable and belong to that individual ipso facto. Moreover, no one may deny the said inherent nature of human rights, as this would mean the denial of the very essence of the Constitution. Now, how is it related to the topic of the modern jurisprudential constitution? The answer is this. In Lithuania, the inherent nature of human rights is expressly provided in one of the articles of the Constitution, which states that human rights and freedoms shall be inherent. This article belongs to the second chapter of the Constitution, which means that theoretically it may be amended or even repealed by the Parliament, the will of the Parliament. However, as established by the Constitutional Court, the inherent nature of human rights is indeed an inseparable element of democracy, which is, in its turn, protected under Article 1 of the Constitution, and thus enjoys the maximum protection and is practically unamendable. Accordingly, the official doctrine of 2014 reads that no constitutional amendment may be adopted which would destroy the essence of the Constitution, denounce democracy, independence, or the inherent nature of human rights. The protection of Article 1 rather means that the inherent nature of human rights has been attributed by the jurisprudential constitution the status of an eternity clause. And this latter concept has been developed by the jurisprudential constitution. I now come to my second aspect. The second important aspect of the jurisprudential constitution is the concept of the constitution as an anti-majoritarian act. Though the latter concept has been developed by earlier jurisprudence only as recently as 1 month ago, the Constitutional Court had once stressed that only a state that respects the dignity of each person can be considered genuinely democratic, as well as that the Constitution is an anti-majoritarian act which protects the individual. In view of this, the democratic state, under the rule of law, in the democratic state, the attitudes or stereotypes prevailing in a certain period of time among the majority of the members of the society may not, based on the constitutionally important objectives, including those as the insurance of the public order, they may not serve as constitutionally justifiable grounds for discriminating against individual persons. In this instance, the Constitutional Court heard a case on family reunification of same-sex couples, which is very similar to the Romanian case, which was heard last summer. These couples had registered their marriage, and such as a marriage or a registered partnership, which would not have been allowed under Lithuanian law. The constitutional concept of marriage in Lithuania is based solely on the union of a man and a woman. Therefore, based on this constitutional concept, a resident permit had been refused. The Constitutional Court thus 1 month concluded that although the objective to protect the constitutional concept of marriage, as concluded upon the free mutual consent of a man and a woman, as well as the historically established model of the family, which is based on this concept, may be considered constitutionally important. However, under the Constitution, such an objective may not serve as a constitutional ground for the disputed regulation and discrimination against families based on same-sex unions. Therefore, though it has been confirmed by the extensive previous constitutional jurisprudence that Article 29 of the Lithuanian Constitution which states that all persons shall be equal before the law, courts, and other institutions, and which says that human rights may not be restricted or privileges may not be granted on the grounds such as gender, race, nationality, language, origin, social status, belief, convictions, or other views, the court had concluded that this provision may not be understood as consolidating an exhaustive list of the grounds of non-discrimination. However, only 1 month ago, this list had been supplemented expressly by the 2 additional grounds. The grounds of non-discrimination with regard to sexual orientation and non-discrimination with regard to the gender identity. The latter development, taking into account that the provision on non-discrimination is actually the provision which has been invoked most of all provisions with regard to human rights by the Lithuanian Constitutional Court, it has to this time not been interpreted in this manner. And the latter development, in my opinion, demonstrates a very gradual and consistent development of the jurisprudential constitution of the court. And I come to my conclusion. Although the Constitutional Court in Lithuania, as most likely other constitutional courts in Europe, is not immune to criticism for being sometimes over-creative, let's say, or for the other sense, from derogating from the real intentions of the creators of the Constitution. I believe that this manner of interpretation of the Constitution demonstrates exactly how the application of the rule of law can ensure that the Constitution is a living instrument which effectively deals with the challenges of the protection of human dignity and human rights. And, in my opinion, in the latter manner, only in the latter manner, the stability and the viability of the Constitution are best protected. Thank you very much.
Thank you. Now we have the presentation of Jose Ignacio Martinez, who is Dean of the Law Faculty and former Vice Rector of the Universidad de los Andes, Santiago de Chile. Actually, he's president of the International Research Group of Human Rights and Rule of Law of this university. He will speak us about the concept of the law, the rule of law in the Chilean constitutional system. You have the floor.
Thank you, Mr. Chairman. Thank you to Rainer for the invitation to this Congress. Dear colleagues, I will divide my exposition in 2 points. In the first one, I will explain the basis of the rule of law in the Chilean Constitution. And in the second, I will explain that in Chile it is not possible to talk about rule of law without judges, because there is a judicial rule of law. The idea of rule of law in Chile is supported in the Chilean constitution system. The Chilean doctrine understands that the rule of law supposes the principio de juridicidad, principle of juridicity or something like that, recognized by the Constitution in this Article 7. The article says, the organs of the state act validly before regular investiture of their members within their competence and in the manner prescribed by law. No magistracy, no person or group of persons can be attributed, even under the pretext of extraordinary circumstances, any other authority or rights than those expressly conferred on them by virtue of the Constitution or the laws. Any act in contravention of this article is null and will originate the responsibilities and actions and sanctions that the law stipulates. This norm comes from the 1833 Constitution, and since this moment it has been considered as the basis of the Chilean public law. The principle has been defined by an important professor in Chile, Professor Sotoglos, as the integral subjection of law of the organs to law of the organs of the state as much as its being as in its acts. This means that in Chilean constitutional system there are no more public power and no more state organs than those created by the Constitution and the laws. The Article 7, subsection 3, says that the infraction to the subsections 1 and 2 determine the nullity of the acts of the state organs. The Chilean doctrine named public law nullity, or in Spanish is nulidad de derecho público. It resembles what in English administrative law is called ultra vires doctrine, and it means that public authorities cannot act outside their powers. Likewise, the jurisprudence of the Constitutional Court and the doctrine understand that the principle of juridicity includes the principle of supremacy of the Constitution, recognized in Article 6. In this sense, the Constitutional Court has said that the constitutional supremacy is an elementary and irreplaceable basis of a legal order and of the state of law. Article 6 says, the organs of the state must submit their actions to the Constitution and the norms dictated according to it, and guarantee the institutional order of the Republic. The principle of supremacy means that the Constitution is over the power, and for that is over the norms created by the Congress and the executive power. But this not means that the Constitution is the cuspid of the whole law, because the Chilean Constitution itself recognizes that the power is limited by natural human rights in Article 5, that says, the exercise of sovereignty recognizes as limitation respect for the essential rights that emanate from human nature. A consequence of both principles, juridicity and supremacy, is another one, the principle of the legality. This principle has two senses. In a first sense, it means that all the state organs and all its competence and faculties are created and assigned by the legislature. The first sense is explicit in those articles 6 and 7. In a second sense, means that only the legislator can regulate, complement, or limit the exercise of constitutional rights and liberties. This principle is implicit in all the chapter 3 of the Constitution about human rights, and explicit in several articles of this chapter. Between those of them, the most important is Article 19, number 26, that guarantee the assurance that the legal precepts mandated by the Constitution to regulate or complement the guarantees that it establishes in or those that limit them in the cases in which the Constitution authorizes it may not affect the right in their essence, nor impose conditions, taxes, or requirements that prevent their free exercise. This norm contains not only the principle of legality about rights and liberties, but the guarantee of essential content, a concept that comes from the German constitutional law. In Chile, the rule of law is guaranteed by a set of judicial procedures regulated by the Constitution. Some of them belong to the courts of the judicial power, and others belong to the Constitutional Court. With the first one, it is possible to make a claim of nullity or of an administrative act because the infraction to the principle of juridicity and the other constitutional principles. And in this first way, most of constitutional rights and liberties are directly enforceable before courts of appeals through writ of protection against administrative acts and against private acts. Because in Chilean constitutional system, the rights and liberties produce horizontal effect, the German Dichtwirkung doctrine. The Supreme Court has determined that these constitutional procedures are supplementary of administrative and civil procedures. The second one are the procedures that permit judicial review of the laws by Constitutional Court. Some of these procedures are a priori judicial review, and others are a posteriori. One of these a posteriori procedures permits that the plaintiff or the defendant of a trial can make a claim before Constitutional Court to get an order of non-application of a legal norm into the trial. In this last case, the Constitutional Court could determine the derogation of this legal norm. Nevertheless, Constitutional Court has said that it has not competence to qualify or pronounce about the political or technical reasons that supports the law submitted to its judicial review, because this control is purely legal. In this control, the Constitutional Court reviews the accordance of the laws with the legislative procedures regulated in the Constitution and the respect of the constitutional values, principles, and rules. In conclusion, Chilean rule of law supposes the principio de juridicidad, principle of juridicity. This principle was designed in the Constitution of 1833 and adopted later in the Constitution of 1925 and the current Constitution. The infraction to Article 7 determined the nullity of the acts of the state organs because the public law nullity. The principle of juridicity includes the principle of supremacy of the Constitution recognized in Article 6. This not means that the Constitution is the cuspid of the whole law, because the Chilean Constitution, Article 5, recognizes that the power is limited by essential human rights. A consequence of both principles is another one, the principle of legality. In its two senses, principle of legality means that the state organs and all its competence and faculties are created and assigned by the legislator, and only the legislator can regulate, complement, or limit the exercise of constitutional rights and liberties. Finally, in Chile, the rule of law is guaranteed by a set of judicial procedures regulated by the Constitution. Some of them belong to the courts of the judicial power, and others belong to the Constitutional Court. Thank you very much.
Thank you, Professor Martinez. Now I have the task to offer an experience also of the Peruvian rule of law, and I will explain one matter in particular about the fight of the rule of law against the corruption in Peru. But I want to first to explain that after the dictatorship at the end of the 80s, began the regime of with the values of democracy, human rights, and open market. No? But after 40 years, more or less, there has been the challenge against our rule of law. No? Because in Latin America there is problem, no, very local, universal problem, maybe poverty, maybe corruption, no, and also conservative dictatorships feelings in some part of the society. I want to explain, for example, that at the end of the past century, there has been impeachments against the presidents in Brazil, 92, Collor de Mello, because he was accused of corruption. He has to renounce to the presidency. 4 years later, in Venezuela, Carlos Andrés Pérez was renounced because he was accused of corruption. But at the beginning of this century, there has been the same process in other countries, but with another things. That's mean, for example, 3 years ago in Brazil, Dilma Rousseff was impeached by the parliament, accused of the bad movement of the budget, but she was not accused of corruption directly, but he was impeached and he has to expulse of the presidents. No? And years before, 2008, for example, also Lugo in Paraguay, he renounced, no, after the attack of the parliament in 72 hours, the parliament oppositor was making impeachment, not very strong, and he has to refuse. And Zelaya, former president of Honduras, also, he was a progressive program, and he was expulsed of the presidency by the Congress. No? That means that before of the democracy, the conflict between the government and the opposition was resolved by coup d'état, by the dictatorship, military. But in the democracy, since the 19th and present century, resolved the problem with the impeachment against the presidents. And there's, in my country, also in Peru, the last year, the leadership of the opposition, Keiko Fujimori, began to make impeachment to the president elected by the people directly. We are our presidency's regime elected directly by the people, and he had to renounce, Pedro Pablo Kuczynski, because he has been accused of the enterprise Brazilian Odebrecht, was contact and was gains when he was Minister of the Economy during the government of Peruvian former President Alejandro Toledo. That means that there is the problem. The stability of the regime in a presidentialist regime elected by the people, when there is accuse of the opposition, not only in the framework of the rights of the opposition to the fiscalization and to put also question to the minister, include the president, but also I think there is more dangers because the crisis it's not only of the government, maybe it's also crisis of the democratic system, of the check and balance between the power, between the parliamentary and the government, and there is a role of the judiciary, because the judiciary in our countries and in Peru has begun to control the action of the parliament when they began to accuse one high authority, when there has been one impeachment. And in my country, for example, in Peru, we had many presidents from the 2000 to now, but the President Toledo, he's with an order of capture, no, because he is in United States, and my government asked the United States government the extradition because he is accused to receive bribes for the Odebrecht enterprise. The fellow President Alan Garcia, also, he is in Lima now with order of he's forbidden go outside the country. He's under the process, and Odebrecht enterprise and executive member has denounced that he received $100,000 for give a conference, no? But he was a pay for obtain contract for infrastructure service at the south of Peru. The third president in the democracy, Ollantumala, and his wife, he was imprisoned the last year, but now he is free, but he's forbidden also to get out to Peru, no? And the last president, Kuczynski, he renounced, and he has also an order to not get out of Peru. The question is, what happened in one country like Peru is totally different like other countries, Latin America. There is empowering of the judicial system to control the high leaders of the democracy because they are linked with the bad treaty, bad contract, no bribery of the enterprise, not only Odebrecht, maybe other enterprise, no? So that is the question that put in the middle of the problem, the relationship between the justice and the politics, you know? Because someone colleagues doctrine say that there is a politicization of the justice when the justice began to control the parliamentary acts, no, that is political matters. But when there is an issue that's the penal content, like bribery, like pay for service, obviously in our system there is two ways: to follow the prosecutor investigation, the judicial process, and to follow the control of the political system. And there is no, the two channels following in parallel. There is no a rational system that maybe is better the political system waiting the result of the judicial accuse of the public in the prosecutor, or maybe finish first the political issue and then follow with the legal and prosecutor system. No, there is no solution. So there is a certain situation very schizophrenic, I think, no, because there are two branches of the power, the parliament and the judicial system, with one matter common, making justice or making political pressure. And there is obviously that the political opposition use also the judge, the procedural against the leadership in the political combat because there is election. So I think that is my proposal in this Congress, that we have to regulate the procedural in the Congress for guarantee that the no arbitrarian decision that has impact, because in the impeachment the opposition can to resign the president because has the constitution the possibility to, against the opinion of the population who won the election of the presidency, could be refused of the presidency before the next election. I think that it's not just. No? So in the inter-American system, there is one standard to procedural when the Congress submit one high authority to a process, no? But it was the experience only of the judges of the Constitutional Court, Ecuador, or Venezuela, or Peru, when was refused by the authoritarian regime, and the Constitutional Court established one standard, minimum standard, no? That's the right of defense to prove, no? And to crossfire, and a decision with reasonability, with a sanction of the national country. But I think that it's different to put on judge before the process, political process, than put an elected for the government, like the president in a president regime. The Constitutional Court the last year was required by the Inter-American Commission to make an opinion about how to judge the president of Republic when they are before a parliament investigation, no? Like impeachment. But the court decide this not is the question is the Inter-American Commission has three demands of the former president of the Brazil, Dilma Rousseff, Lugo, Paraguay, Honduras. He put one case before the Inter-American Commission, and the Commission had to decide if present a file before the Inter-American Court. But the court had the possibility to make an opinion, but as there is the possibility of the Inter-American put this file before the Inter-American Court, the court said, I cannot advance an opinion. I cannot resolve in general the question of the President of the Republic when they are until procedure in the Congress. So there is a doubt in Latin America how to process in each country with rules, with guarantees of the procedural when there is a political process. I think, for finish, that we need to establish some provision at the minimum and following with more guarantees. No? That's true that the parliament is not independent, so we cannot equal a process, political process, like a judicial process. But if not independent, of course, because they are opposition in political sense, there must be at least to respect the proportionality of the force of the parliament. No? They have also to guarantee the defense with all the arms of the president when was accused. No? They have also the necessity, the proportionality of the measure of sanction, not only the most important sanction like rules, maybe the suspense or any way. So I think that we have the task in Latin America. I want to show for the most of the present here of the European Eastern countries that we need rules because the political in democracy has to resolve not like before in Latin America with the coup d'etat, but also with the procedural. If the procedural are under the parliament, where it's very political and in an age very populist also in Latin America, we have the control. This is excess of the democracy parliamentary through the rules that we serve the standard international, but also the national standard of the judicial system to guarantee due process of law in the sense not only formal but also substantive. That's all. Thank you very much. Well, and now we have open the floor to pose the question or any ideas with our speaker. Yes.
Thank you for your very interesting contributions. I have a special question for
Excuse me, please. Maybe you can.
Thank you very much. Thank you very much for your very interesting contributions. I have a specially question for the first contribution on Lithuania. I would like to know whether the Constitutional Court has already declared unconstitutional a constitutional amendment.
Please, do you have?
Thank you for your question. To very shortly answer your question, yes, the Lithuanian Constitutional Court has a very extensive doctrine, actually, with regard to the constitutionality of constitutional amendments. And the approach taken by the Constitutional Court is considerably the wide approach, meaning that the Constitutional Court may investigate the constitutionality of the constitutional amendments with regard to their both procedural and material grounds. And yes, if it interests you, I would be very happy to share this jurisprudence with you that the Constitutional Court has had the chance to declare constitutional amendments unconstitutional.
Yes.
Juan Irarrázaval, Chile. I would like to address a question or a point to you about what do you think about the distinction is being made in political science, especially between electoral democracies and institutional democracies. And electoral democracies, those which have competitive elections, but not necessarily much more in addition to that. Institutional democracy, those which have, say, democracy with rule of law, which have the political pluralism, civil liberties, government abiding or bounded by law as elements which are protected by this concept of the rule of law being of the essence of democracy. In this distinction, the reason is that it was very much celebrated in the late 80s and early 90s from then on, that the world had changed, that from Latin Americans' redemocratizations to the democratizations in Eastern Europe, then Africa, Asia, all the world was turning democratic because elections were being started and replacing the world. And now, this was a big wave. Questions started arising with, after 15 years, where there was like a recession. The wave was not reaching much more in the rest of the world, and even in the world that had been democratized in the 90s, in the early 2000s. There were some questions about the failures of democracy, about corruption, about the guarantees for democratic pluralism, about renewal, governments looking for re-elections, extensions, changes of the constitutions, all the playings about democracy, very different from the tough 30 democracies that started in the say, late 19th century or developed during the early 20th century. Very different thing. So then this concept of electoral democracy started coming. We have to make something to transform all democracies as much as possible in institutional democracies and democracies with the rule of law. I think this conference is great about providing networks and ideas, helping people from Latin America, Eastern Europe, all over the place. Hopefully someday may have from Asia and Africa to support each other, to work in this thing I think is incomplete, how to transform electoral democracies or liberal democracies in institutional democracy, and then have them stable, consolidated, and really abide by the aims that are declared in so many constitutions.
Okay. Someone reaction? Comment?
Well, I think that your intervention or your question is very important because I disagree with the idea that the rule of law is a consequence of only a formal norms. I disagree with the point of view that, for instance, the Kelsen doctrine is important to develop a strong rule of law, because if you have a great norm, a big norm, a constitution, with formal rule of law, but without tradition of rule of law, I think that this constitution will not resolve the problems that we hope that a constitution resolve. The protection of human rights, the protection of the minorities, the protection against the power. No? So I think that in Latin America we have a problem in this sense. I remember that when I was a student, a professor of law taught me about Kelsen doctrine in a period when Chile has a dictatorship. So with the time, I think in these classes, and I conclude that probably Pinochet's regime and people that support Pinochet regime agree with Kelsen point of view of law and Kelsen point of view of rule of law, that all the state is a state of law, and I disagree with this. No, so I think that we have to work very strong to develop a tradition of rule of law, to develop common values in the political community around the idea of some strong agreement in some fundamental values. No, well, that's my opinion.
I would like to react because it's important, the relationship between the condition for one free election and institutionalization of the democracy, of course. But maybe in Latin America we have two problems. No, in some countries the condition for a free election, for example, in Venezuela, is a question. No? The opposition, leadership in prison, don't guarantee for free election for the last election for re-elected for Maduro, close the assembly elected by the people, creating a just a constituent assembly, no, for shadow the work of the National Assembly elected by the people. So we have some countries with this Cuba, of course, other kind of problem of the democracy elected. For example, in Nicaragua, the president Ortega has re-elected against the constitution. The same thing has made Evo Morales. He convoked one referendum for the people in 2016 to know if he could be another one candidate. The people said for most of 60% that no, and he changed the rule and with the opinion of the Constitutional Court in favor of him, and now he will be candidate. So we have this kind of problem of the free election that was a requirement for the institutionalization of democracy. In my country also, for example, Peru, is forbidden one party. The party now is with former member of the Shining Path, the terrorist group, for example. And there has been a debate of after the guerrilla in Peru, they could participate with not with guns, but with the vote. And the official electoral system said no, because he maintained the idea of the army in the future, of the used army. So it's the different kind of debates, and I think that we had the task of resolve in the democracy, maybe with a liberal idea, all may discuss, with a pluralist idea, with a tolerance, but using the vote, but also the democracy's wake set also in many countries, because the society, the culture, the history was no liberal, was sometimes in other sense. And this danger when there's a party, authoritarian party, former authoritarian party has a role in a play of the democracy, using the democracy for expands the ideas that is empty, the values of democracy, tolerance, for example. So I think this is a part very interesting because we are not consolidated democracy. But I think that in our institutionalization, well, we have check and balance, there is election, but it's not enough, like said colleague Martinez, that we need the education, for example, is very important for the values of the democracy. That's mean the values, the respect the human rights, respect the pluralism of the ideas, not only political, ideological, also religion, option of lives, of course, tolerance, and the institutions. It's important to create a critic mentality, because I think the democracy has not the end of the democracy when we arrive with election, or we are in this moment. So I think the ideas of the Professor Peter Heberle, for example, the open society, the open constitution, the dynamic constitution, the interpreting the constitution active, but I think the open constitution, the interpretation also open, but with someone stops, because the judicial activism also is a theme. For the finish, in Latin America, we have the Inter-American High Court. The president is in the other side. And the Inter-American Human Rights Court, in the debate of the academic, is accused of the activist. Very strong activists. It is true, but it's recognized rights that there is no in our constitution. For example, in Chile, recognized the one judge, Atala Rifo, he divorced and he began to live with the other woman, and the father of the children go before the family judge, and the Supreme Court of Chile said that the daughter must be with the father, not with the mother that he was living in a couple with other women. The Atala judge went to the Inter-American Human Rights Court, and the court said that the Chilean state must respect the privacy, the intimacy, the family, other rights, so consolidate this union. But this decision in the debate in Latin America is Inter-American Human Rights could interpret how is the privacy in a family, in a couple of the same sex. That could be applied for other countries of the region also, because they have achieved an interpretation of the rights of the person of LGTB. So there is activists in someone's rights, and the national sovereignty of the state to define in the rule of law how is the rights is shared with the National Assembly or the constitutional system or the judicial system, now with the inter-American system in other cases also. So it's interesting that democracy, we have to define institutionality not only in the national home law, but also now with the international, but in the international, the other ideas of the democracy, of the right also, no?
Yeah, thank you very much. I think it's really important to distinguish between formal and substantive democracy. Formal democracy is just our numbers, but majority is not decisive. It is decisive as a basis, but substantive democracy means democracy filled with values which are expressed by the Constitution normally, and it is true that the legalist view of Kelsen, as it was said, is problematic for democracy. Hans Kelsen, he was cited, referred to today or yesterday, of course, by constitutional justices, is very important for rule of law by creating the constitutional jurisdiction as an own jurisdiction with the power to challenge legislation. But his theory of law, his pure theory of law, is outdated, and it is wrong, I would say. So, because rule of law in a dictatorship is not rule of law. And it is not the literal approach. It must be a value approach. This is combined, and the modern. But so the modern theory and the modern practice is, of course, for this value-oriented practice. And but yes, Kelsen, as a father, maybe of constitutional justice in a certain sense. But he is not the father of modern constitutionalism, not at all. It is against modern constitutionalism. But, well, thank you very much, by the way, for Lithuania. I want to mention that I'm reading about now with great interest this compendium in English of Lithuanian constitutional jurisprudence. I would recommend to do this also, because here you see the high standard of constitutional thinking in Lithuania, and this is very, very good. And the last point is, I think there is a speaker, but at past, I was just informed they are waiting to lead us to the restaurant. This means in how many minutes? 3 minutes, but yeah, well, formally, substantively, maybe 4 or 5, but we should not abuse that, is clear.
Thank you. My question goes to Cesar, because you're talking about, or you talked about the abusive of the democratic institutions. It's been kind of an epidemic, and you gave a few examples from the Latin America, how parliament can abuse its impeachment power, right? And you also suggested that, you know, there should be some minimum democratic principles to be followed by the parliament. But also we know that, as you mentioned as well, the resolutions of the parliament is considered generally as a political questions. So it's not supposed to be under judicial control. So, do you suggest anything? Do you recommend that, you know, these kind of impeachment, for instance, resolutions of the parliaments should be under judicial control, you know, should be put out of the political question, or do you suggest another thing?
Thank you by the question. It's very particular in Latin America because the impeachment is an instrument of the parliamentary regime system, European, but in Latin American, we are, or the original system is the presidentialist, but there has been caudillismo, the dictatorship, civil or military, and the regime must to balance the powerful of the leadership in the presidency and began to put vice presidents, minister, president of government, an institution like called the minister, the censorship, and then the impeachment. No? So it's like a Frankenstein, no? In the political system, because we don't have tradition of the parliamentary system. But now with the populism in many countries, like in Brazil, for example, the forced populists in Brazil get out of the president elected democratically with reason very, I think that was a pretext, no? Because Brazil was in economical crisis, there has been the Olympic Games, the football games, no? And the people wanted to schools, health, no? And now they spend the money of the state, you know, in the corruption also, lavajato, and other bribery of the party corruption. And I think in this moment, cross all the condition for to put the president, the powerful in the president system, under the opposition and before the public opinion to get out with the impeachment. So the impeachment was a process, political and judicial, but the Supreme Court of the Brazil played also a role to put out the president, respecting in all extents the due process of law, for example, because there has not been qualified in the law what the act of the president committed was a case for to expulse. No, so I think if we have in Latin America this problem of the Frankenstein political system, I think the rule of law must to help, establish certain rules, minimum. But we know that in political system, the decisions are with majority. But at least the control of the Constitutional Court, or maybe the Inter-American Human Rights Court, can to guarantee size minimal rules for the process against presidents. No, that's my mind. Thank you.
If I may briefly mention, Professor Arnold mentioned the compendium on Lithuanian constitutional doctrine. And if anyone is interested, there's quite a big section on impeachment proceedings. It's not one of those, let's say, features of law or the functioning of the political legal system that one could be proud of. But with regard to constitutional jurisprudence, Lithuania has quite a wide and extensive constitutional jurisprudence and quite numerous impeachments which have been implemented successfully. One presidential instance, let's say, in 2004, back in 2004, and if I'm not mistaken, 6 parliamentarians which have been impeached. Under Lithuanian law, the impeachment proceedings, they are parliamentary, it's a parliamentary procedure with a referral to the Constitutional Court, which then gives, of course, the legal evaluation of the acts of the politician or the public official against whom this procedure is being invoked. And therefore, the Constitutional Court has given, I believe, 7 of these conclusions. So, like I said, one with regard to the president, and for various grounds, and the 2 newest instances have been from last year, let's say. So we have quite a widely developed jurisprudence with regard to the grounds for impeachment and also to other aspects.
Well, thank you very much. Daniel, Jose, and all of you, and we go to the lunch. Thank you.
you feel like